Hello, and welcome to another DPO advice from Steve. This video doesn't feature the beard. Don't worry, we're back later this year. It's taking some time off so I can wear false moustaches. Don't ask, it's complicated. Today's topics are also seen as complicated, hence we're doing the video, but they're not as bad as you might think. We're going to be covering the various forms by which a person's rights can be given to or shared with other people. I'm discussing England and Wales law here. Law elsewhere is different. The key concept we have to deal with generally is what's called competence or mental capacity. The law uses both terms. Is the person able to safely make decisions about their data, or more broadly their health, welfare, finances, property affairs, etc.? To make decisions requires that a person can understand the consequence of their actions, that they've got the ability to remember the decisions they made, and that they're willing to make those decisions. So all three of those contribute to competence and mental capacity. And please be aware that competence and mental capacity isn't necessarily the same every day or for everything. It can vary depending on the person's medical status, for example, and it's always a judgment call to be made at the point of decision. So there's sort of three categories of person where competence may be in question. So where the person isn't competent at present but will become so. So children, the classic example here, children as they get older become more competent. But also a person who suffered trauma such as brain injury that affected their competence temporarily. I'm sure you can think of others. Where the person is currently competent but can be expected to lose that competence at some point, and that's really all of us, although we don't tend to think of it unless illness becomes an issue. And the third category is where a person is not competent and unlikely ever to be so. And that's commonly people with mental impairment from birth, but also people who've lost competence unexpectedly due to illness or injury. So let's start by looking at the most common case, which obviously is children. Now, a 2-year-old would find it difficult to understand their medical treatment, their data rights, so a parent obviously needs to do it for them. But a 16-year-old is likely to be well able to understand those and probably have strong opinions on it. So somewhere in between, we've got a change between the parent being responsible and the child being responsible. Now bear in mind that under law it's always the child's data. So in terms of data rights, they always have a say. Like with treatments, it's always the child's body. But in both cases, we have to consider both the rights and best interests of the child. In England and Wales, there's a key case on the rights of children, which came from the Gillick case, Gillick versus West Norfolk and Wisbech, AHA 1986. And this revolved around contraception and access to it, but it created a concept called Gillick competence, which is what we now use to help decide if children should be in control or parents of their data. The key statement in the case was a parent's rights for control over a child diminished as that child's understanding grew approaching adulthood. So if a child is able to understand the consequences, then they should, within limits, be allowed to make their own choices. And the age at which this happens will obviously depend on the child. I know a lot of people are waiting for me to quote the Fraser guidelines here. Sorry, they don't apply to data rights. They're purely about contraceptive advice, and I'm not discussing that here. So, looking at data rights, in Scotland they decided to set an age, which is 12, above which the rights of the child must be considered. In England and Wales, it's based on the Gillick competence test, but for a child without some sort of special needs or development delay, whether the child's Gillick competent will need really to be assessed from 11 onwards, because it will vary. I'm not going to go into the detail of how you assess Gillick competence. There's guidelines on that for GPs, but please note it is a GP assessment. The child needs to be assessed. If the child's assessed as competent data, then their wishes must be taken into account along with their best interests. So the child can refuse access to allow access to a parent of their data. Obviously, be careful the child's not being coerced one way or the other. Part of the reason formal assessments are needed. One common case we see is subject access requests from a parent who's not living with the child. Many of these are simply a concern for the child's welfare and perfectly legitimate, but some are looking for information to use against the other parent. It does happen, I'm afraid. Bear in mind that the child's rights if they're old enough, but please be aware that both parents have equal rights, unless a court's removed parent responsibility or there's some other court order. So please ensure that both parents' requests are treated the same. Where there's domestic violence suspected, you can be cautious about revealing data such as future appointment times, addresses, etc. that could result in risk, but just be aware of the fact that both parents have equal rights unless they are removed. There's a sort of a legal anomaly at the moment with children who do not become Gaelic competent for whatever reason, where from 16 upwards, technically parents can't make certain decisions. So at 18, they technically lose all rights to them as they're adults. Basically, recommendation for parents here, it's a damn good idea to apply for deputyship for your children before they turn 18 to avoid possible issues. I had to do this for my son. We'll discuss deputyship and lasting powers of attorney, LPAs, next, but the general advice here is to use the best interest of the person as a guide, and feel free to consult me if you're a customer for advice on these quite tricky areas. So let's talk about adults now. You'll commonly hear three terms being bandied about: deputyship, LPA and EPA. They're not interchangeable, okay, we need to be clear on them. So the first one is EPA, Enduring Power of Attorney. These are getting rarer now because they were replaced in 2007 by the existing instruments. EPAs didn't have to be registered with the Court of Protection, and if the person still has mental capacity, they can still be used in that. But if they lose mental capacity, they can only be used if they're registered with the Court of Protection, and then they're roughly equivalent to lasting powers of attorney. So, lasting powers of attorney, or LPAs. These are given by the person to other persons called their attorney or attorneys, and the attorney can make decisions for the person when the person cannot. Generally, the person needs to have lost competence for the attorney to take decisions for them. Normally only one's appointed, but others are put in as reserves who can take over if that attorney can't take action for whatever reason. Sometimes multiple attorneys are appointed. For details, you need to look at the court documents. I'll come back to that in a minute. The third and final type of document is a deputyship. In this case, the person never had competence, like my son. Okay, so the deputy has to act for them at all times. So effectively, the person never had competence. Therefore, the deputyship is the court deciding that someone else can act for them and saying who that person can be. Bear in mind that the person who can act for them can sometimes be a local authority or other competent body, because sometimes there isn't a family member available that can take the deputyship. Each of these things is a physical piece of paper, and you need to be able to review it and check it's certified by the court. If you've actually got the physical bit of paper, it's got stamps and perforations on it that allow you to check the validity. There are online samples you can view, and I'll put a link in the show notes to that. If someone can't produce the paperwork, or you're not sure, you can check by submitting a form by email, and they send it back within 5 days. There's no charge for checking. I'll put the link for that in the show notes as well. Just to confuse matters still further, now we've got those three types of power, there's also two types of LPA and deputyship. There's a deputyship for finance and affairs and for health and welfare. It's the health and welfare one that's relevant to medical records. If someone only has finance and affairs, we generally not allow them access to medical records. There are possible exceptions, but as a general rule, please feel free to consult me on any cases not sure about. Bear in mind that an LPA generally only allows someone to take decisions if the person is not currently competent. So, for example, they're not conscious or they've lost mental capacity due to illness or injury. A doctor would generally need to give an opinion that they are not competent before the attorney can act. Obviously, sometimes it's pretty obvious. If they're unconscious, you're not going to definitely need an opinion there, are you? One final point about this, which does confuse people: all of these powers only apply to data when the person is alive. LPAs, deputyships and EPAs can't be used for data or most other purposes, to be honest, after the person died. So for a deceased person, we can only provide limited amounts of data under certain circumstances, and that's discussed in much more detail in my video about releasing the medical records of the deceased. So to summarise, children's data is always their data, but parents can act for them until they're competent. Then the child needs to be consulted and can make a decision, which can indeed be, I'll let my parents decide. For adults without capacity, the deputy or attorney with a court of protection order for health and welfare can exercise data rights for them about their medical records. For all of the kinds of orders, except for the older EPAs, and even then only when the patient remains competent, they should be marked with a court of protection stamp so you can verify them. And if you can't verify them that way, you can do it by an email query, which does take up to 5 days. So I hope this helps and is fairly clear. And as always, customers' questions free to email or phone via the normal routes. If you're not a customer like localised services, drop us an email at sales@xcathedral.solutions. Thanks for listening. Bye.